Hello, Stephanie Joy with All Things Social Security. We had a Q&A with a short little clip discussion on a particular topic. So I'm going to attach it for you here. It might be something that you're interested in if you clicked on this header. And following that, we're going to go through it a little bit more. So just wanted to give you the heads up. This is where it started from, and then we'll have the bigger discussion right after. All right, chat with you later. Bye-bye.
All right, midday share here. Had a question from Gabby, and Gabby says, just a few questions for you. She says, okay, so I had my hearing last month. I had gotten denied even though the vocational witness said there isn't anything I can do. By the way, if you hear some noise, it's Tasha. She's right up here. You just can't see her. I had gotten denied even though the vocational witness said there isn't anything I can do. Okay, I'm going to stop you right there, Gabby, just real quick, because the vocational witness does not tell you what you can and cannot do. If that is not part of their testimony, they were never asked the question of what Gabby can do. Okay, let's move along. I have videos trying to explain how they are questioned and how their answers are. If you want to, it's probably under ALJ hearing, that playlist, so you can get a little feel for it better. Gabby goes on to say, I have years of medical records and therapy records to date. I am also keeping up with my treatment plan with my family doctor. I do have a lawyer, and he said everything went well. I am currently 29 years young. I added the young, going on 30 next month. Does age really play a role in the decision? Gabby, age plays a huge role in the laws they have to follow because you do not get credit for being an old coot like myself. And the limitations that we naturally, generally endure, which is recognized at the age of 50 and above in varying ways. 50 to 54 is a certain amount of limitation, and the rules try to then accommodate that to find someone unable to do any job that can be considered in the economy if they meet these other criteria. So they don't quite have to meet the same high mountain of rules you have to meet, but still a pretty stringent set of rules. It's just slightly mitigated. It changes again at 55 and above. Those are known as the medical vocational guidelines. And there is a chart that's publicly available. And Jonathan has a chart on his website too. And you can also get it at the SSA site. Yeah. So age, Gabby, is a huge, huge factor. So Gabby goes on to say, I'm filing for mental health with multiple diagnoses. Does this also play a role in the denial? No, not per se, but mental health issues means you're only fighting on the fact that you allege you can't do any job in the economy. There's over 12,000 occupations, I believe, still on the books, Gabby, that you have to prove specifically you cannot do. Have you thought about it? Do you have a strategy? You have a lawyer, so that's good. And why? And more importantly, everything you said, is that documented over and over and over again in your records with some specificity? Not in the same words you just used, but in other shapes and forms. So the mental health means you have to use whatever your claim diagnoses are, which are presumably provably severe MDIs, medically determinable impairments, whatever those are what you have to then say, and this limitation provably stems from it. Let's say you have an IQ of 60 and you cannot understand when someone tells you to leave the room, go over there and close the door. Maybe you're nonverbal. I'm not talking about you, Gabby. Obviously, I'm talking a little more generally. And it's a person who needs help to know to eat breakfast, lunch, and dinner, cannot answer the phone, pick up the phone, can't talk to people if they ask them a question. I'm giving you a really severe fact pattern here to show you what kind, for sure, of limitations might be found to be so severe that of the mental 4 domains that cover all the mental tasks necessary for even basic unskilled third grader work, that person, if the medical records support what I'm just saying about this person's condition, then that person would be found unable to do all 12,000 plus occupations in the economy based on their limitations. They don't have to have anything physically limiting about them. They could lift 200 pounds. I mean, they could be super strong, super agile, super fast, have no physical conditions whatsoever, but mentally, they can't rise to the third grader job. Okay. It is a very huge mountain, I do believe, to prove. Obviously, people do it. You know, we've had many clients younger than yourself, even not really with the conditions I just laid out, because those people tend to win on recon, assuming they have the medical records. If they don't win on initial and recon, it's probably because their parents hadn't taken them to the doctor in years because there was nothing that could be done. They're just living their life calmly and trying to be peaceful and taking care of their adult child and maybe preparing for his future in other ways, financially and all that, for when they're no longer there. So life goes about and gets on, and sometimes there is no medical treatment follow-up because there's nothing to be done. It's not like cognitive therapy is going to help them. It's not like maybe they've done all the OT and all the PT and they are at the top of their game with that. So that's the kind of situation I could see. They'd have to go to ALJ hearing, and they have to buck up and start getting consultative neurocognitive type examinations, maybe a battery of therapies that show exactly where all these limitations are that the person can't follow a simple command, right? They have to be led by the hand. Maybe it would be a vocational medical person who would be able to say with the proper credentials that they would need to have undue supervision to even accomplish the most basic, easy, simple job for the simplest of capacities. Okay, moving on. I have a whole playlist, by the way, Gabby, on mental health videos of all different kinds within the claiming process. So if you want to take a look at that, it is a very high burden, because remember also, not for the individual I just spoke about, but for most everybody else, it's very subjective, and they are not necessarily going to be saying, I can't even go out in my community alone. Most people can. So if you're able to get out and about in your community by yourself, you're going to have maybe a tougher time. Every case is different, though, and your attorney knows your medical evidence and was willing to take it forward. And I assume he or she is working and getting paid only if he or she prevails. So the incentive to have properly, vetted your case and taken it forward is all there. So you got that on your side. Gabby goes on to say, my hearing was short, about 25 minutes. That's probably standard. It would never be that short with me, only because I'm a do, as you know, and I make sure all sorts of questions are out on the record so that if we have to appeal, we have a kind of a basis. But if a vocational expert and the questions that the judge asks of him point to a situation where the judge is clearly confining himself to an award, then I would say, it looks good. Now, you said you had already gotten denied. So let's just continue on. 25 minutes is pretty standard, particularly if your attorney doesn't ask a lot of questions. She says, I wasn't really asked a whole lot of questions about how it affects me on a daily basis or what might have caused it or anything. The cause is not really relevant per se. Usually, and remember, the cause would hopefully be found in your mental health records. If your providers withheld a lot of your psychotherapy records, which they sometimes do because they have this very pampered carve out under the HIPAA rules, a carve out that only applies to mental health therapists and psychiatrists, and it's the psychotherapy records themselves, a little note taking about where you talked about all the causes, where you talked about certain people maybe. They have a right to not put that out there, even if you ask them to. They can unilaterally just say no. Sometimes the theory is because they weren't taking notes at all, and they don't want to reveal the incompetency. But on the other hand, I know many are like, no, because what if it causes strife within the family if it gets out there? The irony to that whole thing is Social Security records are very confidential, held by the Social Security Administration. I've never heard of any of them getting out, ever getting out. Um, not not that I've heard of in 20 something years. So SSA takes that really seriously. They are under lock and key, if you will. But psychotherapy note takers still use the law to avoid having to provide you with your full records, which has caused a lot of people to be denied their claims. I've known some people who have lived under a bridge literally due to that. Well, I shouldn't say a lot of people, but probably under 3 because they couldn't prove their case. Eventually it was proven, but they had to live there for a little bit. Okay, moving on. I'm waiting for my letter in the mail. I found out I was denied through the online portal, and I had also asked my local Social Security office for confirmation. I'm glad you asked them for confirmation. Going on a little side here, guys. I know they are giving some of the results in the online portal, which is good, probably, right? Sooner you know, the sooner you can, take action versus waiting for a letter in the mail, which is mailed standard, regular mail, and a lot of times mail gets lost. So I like the fact that they're having that double way of doing it. But because I say this only because we have a lot of messaging of the last, I don't know, 4 years or so with the online portal messaging system, that I always think it's nice to confirm something of that magnitude with the local office. What direction do you think I should go in? In your opinion, should I take this to appeals counsel, or would it be faster or improve my odds if I submit a different application? Honestly, I can't really tell you which one to do. If you are going to be having no different evidence than you have now, probably will not, there's a good chance you won't succeed doing the same thing again. As they say, no pun, but it's a bit of insanity to keep doing the same thing expecting a different result. If you change the tenor of what you've been doing to show that it is far more severe, it is closer to what you've described in your function report and everything else. Let's say you're agoraphobic, Abby, and you never can leave your home. You probably had difficulty proving it, because I think if you could prove it, and that's not easy, right? Even with the medical providers, but if you have ongoing discussions for 2 years about your inability to leave your home and all of your telehealth appointments are online because you can't leave your home. And I'm just giving this as an example. This probably isn't you probably don't have agoraphobia, but for those that do, and they're not that common to be that severe, that is a winnable thing. We've done that. It was not easy. I remember being kind of shocked, actually, but it's and for the young people where the physical would have to be so debilitating on top of it to get it further without that, you're kind of stuck. If you are so severe, sometimes the question is, well, don't you ever have you ever thought of getting inpatient admitted to get stabilized for better treatment, more hands-on daily, maybe get those meds adjusted properly? And if not, is that because it's not so severe to get you over the concern and the worry of having to be inpatient? These are all just questions that get floated out there that I'm just sharing with you. And that's why some lawyers will say, and I don't disagree with them, and they won't take a case short of multiple durational inpatient mental health admissions. And they have to be, at some point, they had to be pretty robust, like every year, twice a year. And then if they haven't happened in a few years, that may be a sign of vast improvement over that need. So if they don't kind of pop up with a need, it almost looks like the person has successfully stabilized their problem to at least be able to function out in the community and do some basic work, 3rd grade work, if you want to call it that. Right? So you really have to think hard about what wasn't in your records, what isn't so bad, or is being represented as not so limiting, because what you say is not going to carry the day. It's going to be what is showing up in your mental health records durationally over time, because remember, there's a 12-month duration. So at this point, that duration has to be in your rear view mirror. They're not going to say forevermore, most generally. So that is what I could share with you. Appealing to the appeals council. Well, of course, if you appeal to the appeals council, you cannot file again until they render a decision. So that's really up to you. I assume you're in a safe place and you're not starving to death. You got internet access and a device, so you're probably safe. You could consider appeals counseling it if you think there is something legally wrong that the judge did. Remember, they're not going to appeal you because they think that you're probably disabled. They're not going to remand you or reverse it. They can only do so if they find that the judge missed a step, didn't do something that he should have done, and articulated it. So go through those rules of what the judge is required to do. There's a lot of them. I mean, it's a lot of reading, but and see if that decision he rendered, which you haven't received yet, but you will soon, speaks to it, shows it. What he didn't talk about the, if you, for instance, and I have some videos on this, so you might have to look to, I don't know if it's under ALJ or ALJ denials or ALJ hearing. One of the first things I look at, did he mention every diagnosis? Did he leave any big ones out? Did he not consider, and if he found a diagnosis, that would be an MDI, did he exclude it from saying it was severe when the evidence clearly shows not? And if he did say it wasn't severe, did he not include any evidence that showed it wasn't severe? Did he just come to the conclusion and not explain it? Things of that nature. Sometimes I feel like, I mean, I assume you're, well, I shouldn't assume. SSI, SSD, Gabby, if you're SSD because you did have a work record until things got the best of you and then you couldn't, you will have, if it's an SSD, you have no choice but to appeals counsel that one. If you ever want to do it again, unless you're going back to work, at least part-time, a little bit to get those credits back. Lots of videos on that, guys. Regaining your insured status so you can apply again. If it's SSI, I mean, unless you're like, no, I'm going to insist on trying to win my back benefits I would have gotten that last application, then you have to appeals counsel. If you're willing to try afresh with new stuff, different story. If you can wait and you want to do appeals counsel and you think the judge made some errors and you're going to start changing the evidence that you already have to make it stronger, better, more representative of your realities in this more medically objective way, then arguably an appeals counsel appeal could be worthy, but you have to do a lot of changing of what you've been doing because you are the one that births the medical evidence. Nobody else can do that for you. And that's the stuff that is as the SSA says, the foundation of the whole case. Without that foundation of extremely strong, robust, durational mental health evidence showing this severity that you can't do a third grade job, then it's almost like you'll just be wasting your own time and energy. And then, either go back and file instead a new application or wait until you might want to wait to file a new one because you don't have the goods and you don't want them trampling you, going to deny again. So all sorts of ways to look at that. I'm sure there's different reasonable minds can very much differ on that whole thought process. So anywho, I hope that helps, Gabby. I'm going to try to give you a response here saying, hey, I just did a video on that. I'll talk to you later. Wednesday, guys. In this case, well, today's Tuesday. Every Wednesday, 1 p.m. Eastern Standard Time. I will see some of you tomorrow. Those of you that see this right away, which would be the members, everybody else will see it. It's free always, but you'll have to wait until it comes out in schedule because I do not bombard you if things go right with more than one video a day. Chat with you later. Bye-bye.